Barrie Akin, and my colleague today is Colm Kelly, and we are welcoming you to this Devereux 11s on SDLT and the meaning of dwelling. Back, I think, possibly despite popular demand, because we're going to have to deal with another corner of the SDLT wood today. You'll probably recall that Colm and I did an 11s a few months ago, where we discussed some of the then recent cases on the meaning of garden or grounds for SDLT purposes in the definition of residential property in section 116 FA 2003. The last 18 months or so has seen several tribunal decisions on the meaning of dwelling and suitable for use as a dwelling, and these are concepts also used by section 116 and also by other parts of the SDLT legislation. The decisions are to be welcomed. There was a dearth of authority before that, although just how welcome they are, we'll see as we go through them. Now, there's been a particular focus in these decisions on whether an annex to a home can constitute a separate dwelling, so that the purchaser can claim multiple dwellings relief under Schedule 6B, FA 2003. And that's the focus of these cases, and certainly the first three that we're going to go through. This 11s came about because Colm and I recently discovered that we were both defending professional negligence claims against conveyancing solicitors who were sued, or in my case, were threatened with being sued by their former clients for failing to advise on the availability of MDR and obviously failing to claim it. Now, it seems from our experience, at least, that somebody's going around advertising, I assume, advertising to purchasers of houses that contain annexes of any kind, that they might be able to sue their solicitors if multiple dwellings relief was not considered or not claimed. In the cases we saw, the solicitors received pre-action protocol letters of claim. I should say they were, in my case, it was a very low-level claim. The potential claimant was within the window for filing an amended land tax return anyway. So we were dealing with relatively small losses potentially. Well, thus far, Colm and I have both been successful in batting away these claims, and fairly easily, because the facts were insufficient, in our opinion, to establish that MDR could be claimed with any reasonable prospect of success on the facts. But obviously that won't be true in every case. If you're concerned about this area, this is clearly a seminar for you. Okay, we have a Q&A function in Zoom. It's obviously allows you to ask questions. Hopefully you can see how to access from your screen. And obviously we encourage you to use it. We'll address questions at the end. That's assuming we haven't overrun by too much, and obviously assuming that we know the answers or can give you some guide. Now, what I'm going to do first is to ask Colm to run through the legislation that we're going to talk about. And Colm, off you go.
Thank you. Good morning, everyone. So as Barrie says, the first thing I'm going to show you is the legislation in this area quite briefly. So as Barrie said, the first area we usually encounter the reference to dwelling is in section 116. It's a partial definition, bringing dwelling within the meaning of residential property. It's fairly straightforward, but also fairly uninformative. It doesn't really tell us very much about what it is to be a dwelling. More interestingly, we have the definition as you find it in paragraph 7 of Schedule 6B, and you'll find this replicated in the same terms of pretty much all of the other schedules. So it's going to be relevant for claiming multiple dwelling relief if you've got the surcharge for purchase of second homes or purchases of homes by companies, so on and so forth. And there are a few differences in the language, which may or may not be consequential, as we'll come on to see. The first is the addition of the term part of a dwelling, part of a building rather, which is really just a clarification. The second, I'm going to skip over counts as for the moment, is the reference to use as a single dwelling rather than just as a dwelling. And this is probably simply a sensible clarification to avoid the application of the Interpretation Act, so that things that are singular can be construed as plural or vice versa. Then there's the addition of the word counts as in the start of the definition. Now, Barrie's view, and mine as well, is that this is simply introducing what follows as a definition, but to introduce and think entirely unwarranted note of tension into the presentation, I'm going to come back to a case which suggests that those words might mean that this provision is not in fact a definition of dwelling at all, and it is something entirely different. That's a view that's been taken up in one case, but hasn't found any favour in any of the others. So it's a minority view at the moment, and I'll come back to it, but it probably shouldn't make a difference to the outcome in any cases. Then just to show you the cases we are going to address, we're not going to have more slides with extracts from these up on the screen, but we will circulate the slides later, so you'll have the references to them if you want them. And we're going to offer some comment as we go through them on the kind of issues that might be relevant to professional negligence claims if you get them. So for instance, is MDR available, multiple dwellings relief, when you're advising on a purchase? As Barrie has said, we both had success in batting these claims away fairly quickly. I think in Barrie's case, before litigation even began. In my case, I got the papers after a trial when trial was approaching, and after they received our skeleton argument, they withdrew the claim entirely. And so I think the take home from that is that if you do happen to be in receipt of one of these kind of claims, the first thing is probably not to panic. At least from what we've seen so far, people are putting in fairly unmeritorious claims in the hope of reaching a quick settlement. And with all of that said, I'm going to stop screen sharing and hand back over to Barrie, who's going to tackle the issue of annexes and multiple dwelling relief.
Okay, so the first case that I need to deal with, as you saw on the screen, is Fianda. And this was a decision, you've already seen the reference, it's 2020 UK FTT 190. It's a multiple dwellings relief claim case, an FTT decision of Judge Citron, and it was released in April of last year, just about a year ago. So brief summary of the facts. The appellants bought a detached house for £575,000, and it had an annex. The annex was at the rear of the main house, and it's connected by a corridor. The main house seems to have been reasonably substantial. At the relevant date of completion, the annex itself had a sitting room, a kitchen utility room, a single bedroom, and a shower room, which to me, if I look at it in lay terms, sounds perfectly habitable and sounds in lay terms perfectly like a dwelling, although no one actually occupied it at completion. So what we were looking for was suitability as a dwelling. Access to the outside world was either through French doors in the sitting room of the annex, or back through the corridor and out through the main house. The annex didn't have its own separate post box. It wasn't separately dealt with for council tax purposes, didn't have its own utility supply. Now, in the corridor, there were what are described as door jambs, which I think means the sort of framework that you put a door into, and doors could have been positioned there, and that could have physically isolated the annex from the rest of the house, but there were no actual doors. And the appellants argued that the annex was suitable for use as a single dwelling, those words that we've had on screen before, at the effective date. The lack of a letterbox and its own utility meters didn't affect that, because the test was physical suitability, and the lack of a door was easily capable of remedy. So it's a suitability case. Judge Citron was the first person to look at this legislation effectively in litigation that we're aware of, and this is how he prefaced his analysis. And he said this: we approach suitability for use as an objective determination to be made on the basis of the physical attributes of the property at the relevant time. Suitability for a given use is to be adjudged from a perspective of a reasonable person observing the physical attributes of the property at the time of the transaction. And can't object to any of that. That sounds all very fine to me. So he referred to it being determined by objective physical characteristics. And then he went on to discuss what is required to do that. The dwelling must accommodate the need to eat and sleep, and basic needs such as personal hygiene and a reasonable degree of privacy to function as a separate dwelling. So that's where the separate dwelling word comes in. And he also dealt with defects, because there were some defects in the property at the time. So the central heating boiler needing fixing didn't render the property unsuitable. But one thing he did discuss in detail was the need to exclude strangers. So the fact that there wasn't a lockable door between the annex and the main house was clearly going to be an issue. He recognized that may not be an issue when you have separation between two units by a different floor, for example. But this is what he said to encapsulate it. This is in paragraph 52 of the decision. A dwelling is the place where a person or a group of persons lives. Group of persons, I should say. A building or park can be suitable for use as a dwelling only if it accommodates all of a person's basic domestic living needs: to sleep, to eat, getting a bit Hamlet-like there, to attend to one's personal and hygiene needs, and to do so with a reasonable degree of privacy and security. That phrase privacy and security will come back. By requiring that the building or park be suitable for use as a single dwelling, the statutory language emphasizes suitability of a self-sufficient and standalone use as a dwelling. I use single dwelling, so use as a single dwelling excludes, in our view, use as a dwelling joined to another building. So we've got two sort of threads here, the privacy and security and the attachment point. Now that, in my view, is way too broad. What about a house split into two self-contained flats which share a front door and an entrance hallway but are otherwise self-contained? If you take what he says literally, that would not be two single dwellings. I'm not sure about that. So he went on to say, in the eyes of an objective observer at completion, the main house and annex were eminently suitable for use as one joined dwelling. In such circumstances, it seems to us that such an observer would not reasonably conclude that they were suitable for a different sort of use on the basis of a new physical feature being added. So, for example, we could have put in a door and with a lock. So he also said that bonds of family weren't relevant to suitability. The property needed to be suitable on a standalone basis. And what he was getting at here was that this lack of privacy and security point may not be an issue, it was argued, where, for example, an adult child of the family or a grandparent lived in the annex, and so therefore nobody would care if they walked around in their underpants. I'll refer to Fiander again at the end of my piece, but I think it's worth pointing out that this concept of a reasonable degree of privacy and security, which is held to be one of the crucial factors here, doesn't really emerge as a key feature from any of the old case law that Judge Citron actually considered. And we'll elaborate on that a bit later on. So what I want to do now is come to merchant HMRC, or marchant if you're posh, I guess. It's another MDR case in the FTT, and as with Fiander, suitability for use was the issue. It's a decision of Judge Brooks from July of last year, and it was decided on the papers, so the tribunal didn't have the benefit of oral argument. As for the facts, the appellants bought a terraced house in Wandsworth for £1.9 million, and it had a lower ground floor annex comprising a kitchen, shower room, living room, bathroom, and a bedroom. And access to it was via a staircase off the front hallway of the house. Not unusual at all. Judge Brooks followed what was said in Fiander, and he dismissed the appeal in quite short order. In fact, much of the case was taken up on procedural disputes. There was only a very small number of paragraphs towards the end which actually dealt with this issue. And I suppose if the lack of separation, you could walk straight down to the annex, down the staircase from the front hallway, if that was a key factor, and also the joining together point, the appellants in Merchant could hardly have expected to do any better than the appellants in Fiander. Well, or could they? Because this is what Judge Brooks said, that there are factual similarities between Fiander and the present case is clear and obvious, albeit in this case, access to the annex is through the main house using a common hallway. rather than a connecting corridor. I consider it appropriate to adopt the reasoning of the tribunal in Fiander, particularly leading to the inevitable conclusion that the claim for MDR in the present case cannot succeed. So he did adopt both of the strands of the reasoning in Fiander, not a single dwelling point and the privacy and security point. That takes us to Partridge, 2021, UK FTT 6, another MDR decision of the FTT, this time of Judge Swinnerton, actually decided in November last year, but reported this year. And again, a suitability for use case. And again, on the papers, this time the annex was within the house and appears to have had a separate entrance door and an internal door to the rest of the house that was lockable. The annex had its own kitchen area, but its bathroom could only be accessed from the main house's hall. So you had to go out into the hallway to use the bathroom, which doesn't sound great in terms of where the case law is going. Now, on this point, the appellants argued that the occupants of the main house wouldn't need to use that particular bathroom. Presumably they have other bathrooms in the house. But the difficulty with the case is that it is rather confusing because the facts that are referred to earlier in the decision, which I've just summarized, are rather contradicted by the floor plan that the appellants had used in evidence, namely that the annex didn't have its own bedroom, no access to the study, snug or dining room without going through the main hall. So the facts seem to turn around partway through the decision. So given that, I would have expected the tribunal anyway to seize upon these particular facts and say, well, look, it's all scattered all over the place. It's not even a coherent unit. But it still dismissed the appeals, but it simply adopted the reasoning in Fiander without actually elaborating at all. All that Judge Swinnerton said was this: in the absence of specific circumstances, such as the parents of one of the appellants intending to live in the annex, the main house and the annex would not be suitable for use as dwellings due to the insufficiency of privacy and security for the occupants of both the main house and the annex. I don't think Fiander actually did say that you could remake a dwelling in a single dwelling if the circumstances of who occupied were different. I don't think Judge Swinnerton picked up what was said in Fiander properly at all there. So the case isn't really very helpful, but it does, at the very least, illustrate a trend that a lot of annex cases are going to be difficult for the taxpayer. And so where are we going in all of this? Well, I can't help feeling that the tribunal isn't getting fully to grips with the legislation here. That may be just the selection of cases that it's had hasn't helped it, but in all three cases, the critical words that we had to look at were suitable for use as a single dwelling. And that's in a schedule which gives a valuable relief when the subject matter of the transaction consists of two or more dwellings. But as Colm said earlier, these words do pop up elsewhere in the legislation. In all of these cases, the tribunal has gone down the privacy and security route to deny that the annex is suitable for use as a single dwelling. But this need for privacy and security seems to appear for the first time, actually, in paragraph 52 of the decision in Fiander. The older rating and council tax cases that are referred to in Fiander don't seem to be unduly concerned about privacy and security. And the House of Lords decision, where the meaning of dwelling is discussed, a case called Ura Temp Ventures, I'll give you the reference, it's 2001 UKHL 43. That doesn't appear to focus on privacy and security. And actually, it's an interesting case to read. There are quotes from Dickens and, well, quite a number of authors, actually. It's a very literary House of Lords, quite clearly. Now, as I've already said, there's another point here, this being joined together, preventing you from having a dwelling point. And that was very useful, perhaps, in getting to the right decision, and certainly in the first of the cases, Fiander. But it seems to me to be far too wide. I can't help thinking that in all of these cases, the tribunals found an easy formula to defeat what might be considered to be an unmeritorious MDR claim. But I wonder what would have been the position in Merchant if the stairs down to the annex had actually been boxed in with a lockable door at the top of the stairs, because then the security and privacy issue you would think would go away. Would the common entrance hall have played a part in denying the relief, or would the joint together point have been held to be relevant? Now, I think there's a danger here that the next unmeritorious case might bring us to a decision which potentially scuppers other more meritorious claims. And you can't blame the tribunal for deciding what's in front of it. But having a wider view to where what they say might be relevant in more, inverted commas, normal situations is something which I think the tribunal should be trying to do. Let me leave you with a thought on the privacy and security point. If that's a reason for depriving dwelling status to the annex in one of these scenarios, why doesn't it also deny dwelling status to the main house? Can't be right, can it? I think also, before handing back to Colm, it's worth me saying that HMRC's published views as to what is a dwelling or a single dwelling, and you can find them obviously in the manuals, they are conservative, as you possibly might expect. And HMRC have demonstrated in the cases that we've been looking at that they throw an awful lot of extraneous and I would say frequently irrelevant material in front of the tribunal when they actually defend the appeals. That may be due to the nature of the individual litigators. It may be a policy matter. That's to be seen, I think. But let me put it this way. Based on what I've been saying, if we're looking at a multiple dwellings relief claim, which is remotely regarded as unmeritorious by the tribunal, then I think taxpayers are going to suffer and they're going to struggle to actually get through. So with that note, I'm going to hand back to Colm to deal with some other scenarios.
Thank you. So I'm going to be looking at things from, I think, the opposite perspective to Barrie. Barrie's been telling you about how much work needs to be done to show that something is a separate dwelling. I'm going to be looking at two cases where the issue is just how dilapidated or dangerous does a building have to be before it ceases to become a dwelling entirely. So while Barrie's examples are possibly more useful for planning, for figuring out if MDR is available when you're making a return, at least as the issues arisen in the two cases I'm going to look at, this is going to happen the other end of the spectrum where your carefully laid planning has somehow gone awry, and then you break the glass and you hammer the big red button that says not even a dwelling at all. So the first of those cases is called PN Bewley. And it's a decision of Judge Thomas, released in January 2019, and it was about a derelict bungalow, which also contained asbestos, and it was acquired by a company. So that meant that they had to pay the 3% surcharge for the acquisition of dwellings by companies. However, it could potentially get out of this if the building itself was so dilapidated that it didn't even qualify as a dwelling. The physical condition was described in a report, and the tribunal recorded that there were asbestos-containing materials that had been identified during the demolition survey. The asbestos materials identified were in good condition with risk scores of 3 to 6 out of 10. Confess I've no idea what that actually means in practical terms. The recommendation for these materials was urgent removal, so that tells you something. The building notes show that the heating system had been removed and the remains of Hessian insulation was still under the floorboards. So the two issues that were relevant to the condition of this property were the lack of a heating system and then the asbestos and the presence of asbestos. And one of them is significantly more important than the other. So it's important that this case doesn't get misused. But it raises an interesting point about this idea of latent dangers in property, the presence of asbestos here being an example. Just how dangerous does something need to be before it ceases to be suitable for use as a dwelling? So bearing in mind how the presence of asbestos was actually deployed here, the way the appeal was made to HMRC was that the property was not habitable and refurbishment was not viable because of the asbestos content. So they're only saying that the relevance of the asbestos was that it prevented refurbishment, but the condition pre-refurbishment meant it wasn't habitable, so wouldn't qualify as a dwelling for that reason. So the decision tackled a few, I think, fairly straightforward points. It said that you're assessing suitability at the time of the purchase. You're not concerned with capability for future use as a dwelling. So if something is capable but not suitable for use as a dwelling, it is not a dwelling. And here the focus was on the fact that the radiators and pipework had been removed. So paragraph 53, the tribunal says, taking into account the state of the building, as shown in the photographs on Mrs. Bewley's phone, with radiators and pipework removed, and with the presence of asbestos preventing any repairs or alterations that would not pose a risk to those carrying them out, we have no hesitation in saying, in this case, the bungalow was not suitable for use as a dwelling. So the relevance of the asbestos here was not that it was so dangerous simply for you to be in the room and breathing it in that it rendered it not a dwelling. The relevance of the asbestos was there was no prospect of the works being carried out to install a new heating system. And the absence of a heating system was what made it not a dwelling. Now, this hasn't been addressed in the Revenue's SDLT manual, but one can imagine this case could be misused because asbestos sounds scary and is potentially seen as a kind of red flag, and there's a danger of focusing on that to the exclusion of what's actually said. The outcome, in my view, in this case should have been exactly the same, even if no asbestos was present. If you're assessing suitability for use on the effective date of the transaction, if the fact there's no heating system is in place stops it being a dwelling, then that is the answer. It's not actually very relevant that fixing that would be rendered more difficult by the presence of asbestos. So the second case is Fish Homes Limited and HMRC. And this is a case about the 15% rate. There was a purchase of a dwelling by a company and it was over £500,000, normally paying 15%, but it was purchased as part of a rental business. So that normally obviously takes you outside of the 15% rate. However, the owners of the company had, within a period of 3 years from the purchase, allowed their daughter to live in the flat. And then that meant the relief from the 15% charge was withdrawn. So what they wanted to say was that, well, anyway, it wasn't in fact suitable for use as a dwelling. And the issue here was the fact that the flat had aluminium composite material cladding on the building. And it was described by the tribunal in, I think, fairly dramatic terms, where it says, unbeknown to Mr. and Mrs. Fish, at the time of the purchase, at the time Fish Homes contracted for and completed the purchase, the flat was in a block which was covered in cladding, which was similar to that used on the Grenfell Tower block, in which there had been a disastrous fire exacerbated by cladding in June 2017. It was only hours after completion that they were told of the problem with the cladding. So a very nasty shock for the purchaser of this particular flat. There had been some testing carried out which confirmed that the aluminium composite material cladding was not in line with the requirements for material of limited combustibility. A walking fire brigade watch had been implemented. The NHBC had accepted a claim by the management company of the block of flats on the basis that the cladding did not comply with building regulations. Now, this is where I'm going to come back to the point I flagged about the words counts as in the definition here, because Judge Hellier adopted a different construction of that definition to what we've seen thus far. He said that the use of the word counts as there, its function wasn't to define a dwelling, it was to extend its meaning. So in effect, you're left with a kind of two-stage test where you ask first, is something within the ordinary meaning of the term dwelling? And then, if the answer to that would be no, you can check, but does paragraph 7 extend the meaning of the term dwelling such that something ordinarily wouldn't be described as a dwelling is in fact within the statutory definition? So the judge said that he recognized this was a different approach to what had been adopted before and was going to go on to apply both approaches. And I think whichever approach you apply, you should arrive at the same outcome. But in illustrating this, he gave the example of a railway carriage sitting on a piece of land, which he said in ordinary usage you wouldn't think of as a dwelling, but which might come within paragraph 7 and count as a dwelling. Now, there are possibly some missing facts from this decision. There's simply a reference to a railway carriage sitting on a piece of land. What's not mentioned, but I think you have to infer, is that the railway carriage has been somehow adopted such that you have cooking and hygiene facilities and sleeping facilities in the railway carriage. if none of that was present, I don't think that the definition here would operate to extend the term dwelling to that railway carriage. But so Judge Hellier applied his analysis and said, look, you don't normally think of a railway carriage as a dwelling, but if it's got all of these things in it, then it's suitable for use as a dwelling, and it counts as such because of paragraph 7. So that is different to how it's been approached by the tribunal and the other decisions. I'm not sure this two-stage analysis really changes or adds anything. Does it really add anything to the statutory question to know whether or not something counts as a dwelling, and if that's different from the ordinary language, when either way you're arriving at the same outcome? You should be applying the statutory language to the facts in front of you. So I'm not sure that's a particularly valuable way of thinking about it, but it is there and something you might want to grapple with to see if it produces a different outcome. I think in most cases it should. There were some other points that were useful, you kind of usefully illustrated in Bewley, or rather Fish-Holmes rather. So the judge agreed that there was a difference between something being capable for use as a dwelling and suitable for use as a dwelling. And the difference was that capable suggested some possible adjustments could be made to the building to make it suitable, whereas the use of the term suitable suggested the present condition of the building was what you are testing. So much like the other cases, you're testing this on the effective date of the transaction, and you're not unduly concerned with what adaptations or alterations you might theoretically make to render it suitable for use as a dwelling. Then coming back to the danger posed by the cladding, again, this is a latent danger. And the judge accepted that if you had a danger that was such that a reasonable person would say it's too dangerous to live there, then the building would not be suitable for use as a dwelling. So the examples he gave of that were, let's say, the walls being in such a dangerous state of repair that the building might fall down at any time. So, you know, all of the things you want are in there, your cooking facilities, your bedroom, everything, but the house may fall down on you. Very reasonably, you wouldn't call that a dwelling because it's too dangerous to live there. The other example, which is slightly different, is the presence of radioactive pollution, which again would be sufficiently dangerous that you couldn't live there because there's an ongoing and real threat to your health. Though I'll come back to that because you can take that a little bit further and closer to the borderline. But just focusing on the cladding itself, the judge concluded that the danger it posed was not sufficient to render the building not a dwelling. He said, the risk which the cladding on the block created was a risk that if a fire started, if it spread to the cladding, it would maim or kill occupants of the flat. The contingency that the risk would fructify only if there was a fire and only if it spread to the cladding, in my view, reduced the level of danger. I think that's a sensible approach. When you're talking about risks that are in some sense contingent, it's appropriate to discount them as a kind of present danger by reference to the likelihood of the contingency occurring, because the panels themselves weren't going to spontaneously combust. They weren't going to cause the fire. They were just going to make the fire spread quickly and possibly have a worse outcome if in fact the fire spread to those panels. So I think that's an appropriate way of thinking about it. But let's go back briefly to the radioactive pollution. Now we have Barrie back. He's briefly been lost to all of us. So I hope you can all breathe easy now. Thinking about that radioactive pollution he gave as an example, closer to the borderline would be something like a gas leak. So if on the effective date of the transaction, the house is full of gas, potentially combusts with someone lighting a match or creating a spark, at that point, you clearly can't actually occupy the house. But I'm not sure I would feel comfortable saying that that renders it not suitable for use as a dwelling. It's a relatively quick fix. It also plays into one of the points that was made in Fiander about the difference between kind of alterations to the property and putting it back in the condition that it previously had been. So when Barrie talked about the door jamb, the judge there had mentioned that there was no evidence that there previously had been a door hung there, or that simply the work of 30 minutes to hang a door could put the property back in the condition it once had been. That was different somehow to the idea that you could do something new and add something to the property by adding a new door that had never been there. And those were to be treated differently. You could take account of the first, but seemingly you can't take account of the second. And I wonder if that might explain why it is that an easy fix by turning off the gas mains might be explicable and allows you to say that something is suitable for use as a dwelling. even if it's not, because it isn't about a future alteration or change, though it's not very satisfying or rigorous intellectually as a way of explaining the difference, but it at least helps you muddle through what feel like some sensible outcomes. So that's what I'm going to say on those. The last thing I want to talk about is to give a brief update on Gardiner grounds, which was our last talk, because we've now had the upper tribunal's decision in Hyman and others. So this was 3 conjoined appeals, all of which Barrie and I spoke about last time, and the video for which is, I think, on the Chamber's website and YouTube channel. So if you do want to go and refresh your memory, it's there in glorious Technicolor. But there was an appeal to the upper tribunal, all these 3 appeals bundled together, and they'd secured new counsel who put a different argument to what had been put below. Below, they focused on effectively the use to which land was put to determine whether or not it was Gardiner grounds. There was a new argument run on the language of section 116. We'll say something is residential property if it forms part of the Gardiner grounds. The focus was on that language of part of. And the appellant's submission was that the land in question, even if it was part of the garden or grounds of a house, had, in addition to satisfy the test that such land was needed for the reasonable enjoyment of the house, having regard to the size and nature of the house. So that additional requirement to be needed for the reasonable enjoyment was said to flow from the language of part of, something being residential property if it was part of the Gardiner grounds. The upper tribunal rejected this submission, and it said, forms part of in section 1161b. He submitted that those words showed that it was not enough for a piece of land to come within the ordinary meaning of a garden or grounds. One had to go on and ask whether the piece of land was part of the garden or grounds, and it would only be part of the garden or grounds or a relevant part if it was needed for the reasonable enjoyment of the house. So the upper tribunal said that wasn't what the language of forms part of was doing here. It's not requiring an additional connection to the property. It's just recognizing the fact that you might sell only a segment of the land, which is the garden or grounds, and that should still qualify as residential because it is part of the garden or grounds. Section 1161b wasn't trying to do anything more with that language, so there's no additional test. And then the appellants there recognized that if they failed in that submission, that the decisions in the first tier tribunal, which had all gone against them, should stand. And so they did. Now, that's all I was going to say. I see that we don't have any questions in the Q&A function, so we'll take that as an encouraging sign that we've been so comprehensive and informative you didn't feel the need to ask for any clarification. I'm going to pass back to Barrie to see if he has any final thoughts or anything else he wants to add. But of course, he's muted at the moment, so we'll have to fix that.
That should be better now. Hopefully you can hear me. Yes. I did want to say a little bit going back to the annexes, because I can't help feeling that maybe we're only seeing a partial picture when we talk about these 3 relatively recent cases. And for all I know, it may well be that meritorious claims where there are things which are clearly annexes and which don't appear in any way to be an attempt to game the system might well be getting through very easily through HMRC and never getting to a tribunal. I can't say that for sure, but I suspect that may well be the case. Where the difficulty arises is where there may be a choice as to or maybe where one is very near a borderline as to what is, in anybody's eyes, an annex and what isn't. And my sense is that the tribunal is going to try and guard this ground quite carefully and stop what it perceives to be a possibly abusive attempt to exploit multiple dwellings relief. I can't be sure about this, but that I think is where it's probably going. And what that means for planning is an interesting question, because very substantial properties going at very substantial prices will get a very substantial reduction in SDLT if they are able to claim multiple dwellings relief. The pragmatic difficulty of making arrangements to make sure you've got something which looks more like 2 dwellings pre-completion in negotiating with your vendor may be quite substantial. Now, the occasional savvy vendor may well think that they can negotiate a slightly better price if they can assist the purchaser in getting multiple dwellings relief. And there may be some work that can be done there in, I should imagine, very high value cases. And that's, I think, something which we could explore with some interest.
So we have got one question in the Q&A, which I think is interesting. So we're asked, how critical is separate control over utilities? So my thought on this is that it is relevant, but what you need to think about is explaining why it's relevant. So it seems to be on the revenue's checklist of things they ask about, and it's one of the facts they always throw in front of the tribunal that there may not have been separate control over utilities. I think its relevance is going to be to that issue of privacy and separation. Because it may be that that's part of the picture, which shows that the annexed cannot function as a completely independent flat, and you're in some sense dependent on the more major aspect of the building. So if the people in the main part of the house go on holiday and they decide they want to turn off the water mains, are you cut off in your annex down in the basement. However, if you think about it, it wouldn't be particularly unusual to imagine a scenario in which a landlord owns 2 flats in a single house and hasn't had them separately metered and simply charges the tenants, a flat rate, splits the bill in half every month and says, this is what you're going to pay me, or a quarterly charge, without there being. So it's definitely not one of those situations where you absolutely need to have it in order to show a separate dwelling. But my view is that it will add to the picture of you not having a kind of, it not being sufficiently separate. So I think it's of comparatively low importance. So Barrie, what do you think?
Yeah, I'm absolutely with you on that. I think it's one of those factors which HMRC are very keen to throw in. As I was saying, they do throw an awful lot in these cases to see, I suspect, to see what sticks. In most cases, I think it would be a minor point, but it is to the point. I had one not long ago where the central heating for the entire unit was in the main house and could not be controlled from the purported annex. I think that might look a little bit more questionable than just not having control over who turns off the stopcock and how the lights can stay on.
I mean, I think partially it's probably a product of whether or not something actually requires any kind of active engagement for you to benefit from it. So you can, once the electricity and gas are left on, there's not really anything you need to do to ensure a continuous supply to your house. You just measure how much you've used and pay for it. Slightly further along that spectrum is heating, where you're going to be, controlling when it comes on and when it goes off during the day. In my case, the issue I pointed to was the basement annex we were dealing with didn't actually have a separate working kitchen. So that's much further along that kind of privacy and separateness spectrum. If you have to go upstairs to cook all of your meals, then you really definitely don't have a separate dwelling, in my view. So you can kind of understand things along that spectrum.
Yeah, but having said that, if you go back to Aura Temp Ventures, which I mentioned, that was whether a hotel room was a separate dwelling, and it was. Now, obviously, it was for a different piece of legislation, but the lack of cooking facilities was regarded as not being relevant.
Indeed. So, what I thought when you were discussing this, one point that occurred to me is, I think a lot of these cases, you have to view them in their time, because although Aura Temp wasn't that long ago, it was discussing a situation which is, I think, now kind of become extinct, which is someone who was a long-term resident of a hotel. And one of the issues that cropped up was whether or not it would be relevant to something being a separate dwelling, whether you had access to your own bathroom, whether it was private. And Lord Millett just dismissed that completely out of hand and said, no, of course not. If people are, sharing one bathroom in a hall, that's not a problem. And he talks about that kind of now old scenario of people, living as long-term residents in hotels. The Fawlty Towers example leaps to mind. He also mentioned, dons in Oxbridge colleges and things like that, which wouldn't have access to running water in their room, and some slightly dated examples. I think now we've seen the emphasis on the access to separate kind of washing and hygiene facilities in the tax cases, and that probably reflects the fact that people aren't really going to be tolerant. If you went to a hotel these days and discovered you didn't have your own bathroom, you'd probably feel a bit put out, because the expectations of what it is to have some kind of separateness are different.
I see that, and it makes an awful lot of sense from a metropolitan point of view. But believe it or not, there are still people in this country who don't have running water.
Ah.
I mean, the house directly across from where I'm sitting a Victorian terrace. Until 15 years ago, that didn't have an inside toilet or a bathroom. Still a dwelling, still being used as a dwelling.
Indeed, though of course we've realised it would be possibly tricky to accommodate that within the decisions we've seen in Fiander and so on. We've got one more question, which I think we can deal with briefly before we sign off, which is that, is it possible to summarise the key points in which you'd recommend an annex should look like to be able to benefit from MDR? So obviously this is all simply a summary of the cases and not advice, but if you're looking at Fiander, you want to have those key facilities, which is going to be somewhere to sleep and to eat, and to prepare meals and to wash, and it needs to be separate. So you want a locked door. That's going to be, it seems like, the minimum requirement. And then, as Barrie said, whether or not a shared hallway from which you find that locked door takes you out of it is a slightly more open question, not decided yet. Do you think that summarises it?
Well, I certainly do. I think we are struggling here for a rigorous definition being developed by the tribunal out of the legislation. The legislation is not laser point accurate, and the tribunal is doing the best it can. And I think from what Colm has just said, gives you a fighting chance. I suspect the tribunal and HMRC they'll know one when they see one, but that's not a very good way of planning, unfortunately. But the more you can bring it within the cases, I suspect what will happen is that the joined together point will probably be something which is quietly forgotten in cases where you have separateness.
Yes. Okay. Barrie, I don't know if you can see it. There's one more question in the Q&A. Do you want to tackle this, or shall we sign off?
Let me see if I can see it. What do you think would be relevant to considering whether service flats are dwellings? Well, that's very interesting, because I think the concept of service flats, I think, is a bit elastic. I thought that most service flats did have catering facilities, somewhere you could sleep, somewhere you could shower or bathe, and a front door. Unless I've got that wrong, it would seem to me that they ought to be in with a very strong chance of qualifying as separate dwellings.
So we have one more. I think we'll draw a line after this one. So I think this is an area where I think Barrie and I might slightly disagree. And the question is, if you have a separate cottage with its own bathroom but no kitchen, is that likely to be fatal? So the decision in Fiander and the others talk about a place where you can prepare and cook food. And that suggests that cooking facilities are going to be thought of as necessary for separateness. But as Barrie has said, the House of Lords and Eurotemp really kind of cast that aside very quickly and said if you had a microwave or a hot plate, that was going to be more than sufficient for a separate dwelling, and you possibly didn't even need that. The fact that you could simply bring in takeaway food was going to be enough. So there is at least a respectable argument that if you were going to appeal a decision that was decided on the basis of a lack of a kitchen, that you could argue that it isn't relevant. I think, based on what the FTT has said, at the moment they're unlikely to accept that anywhere without a kitchen is a separate dwelling.
I'm intrigued by this because there's a VAT case called Agudas Yisrael, which is about a care home for the elderly where there were no cooking facilities, but there was a space for a microwave, and the individual units were dwellings as a result of that. This was a VAT case. It does seem to me that there's a balancing act here, but I would have thought that there would be some prospect of getting through on this, but it will be difficult. If it's an entirely separate building in the grounds, then I think you're in a better position than a conjoined annex, let me put it that way.
Yes, because I suppose you're not folding it into a larger building by saying you'd have to go upstairs, and that's indicative of what the real dwelling is. It's just that you've chosen to buy a particularly austere cottage and live there. Okay, well then, with that said, I think we're going to call a halt to the questions because we're not getting any more, and say thank you everyone very much for attending, and we'll hope to see you at the next 11Zs, which you'll hear about in due course. So,
yes, I hope it's been informative, and if you do have any further questions that you want to pose later, we're available for discussion.
Bye everyone.
Bye-bye.